Okay. So first thing first, as usual, I want to tell you that this is a pro bono class and I'm just a pupil. I'm not a qualified lawyer yet. And this class is particularly aimed to cover the examination areas of insolvency, as well as your winding up. All right. We could not have possibly have adequate time to cover all areas. So, okay, we'll have a look at how to make a person bankrupt in the first place. Okay, then this insolvency and winding up, to me, it is a better what we call better choice as compared to probate. Reason being, you are given a statute which consists of your Insolvency Act as well as your insolvency rules during the examination. So this serves to be a bigger advantage to you, in answering the examination question well. Why I said so? Because you have to be very specific in answering the question in CLP examination. You cannot just write the main provision itself. Sometimes you have to go to the subsections of the provisions. So for those who attend today, I hope this class will sincerely benefit all of you. And first thing first, okay, we must be very familiar with the steps to make a person bankrupt. This is very important because, as you all may know, this examination, the PP paper, is about procedural paper. It's all the technical stuff that you need to master. Okay, so your question will evolve in the areas of how to make a person bankrupt or how to oppose bankruptcy proceeding or how to wind up a company or how to oppose a winding up of company. As simple as that. All right. So we will talk about how to make a person bankrupt first. Okay. So these are the 8 steps that you must master by your heart, I think. Okay. The first step being you must have a civil action which give rise to judgment. That means you must sue a person by writ and statement of claim, etc. Then the trial had completed in which the judge or the court award a judgment to you. Okay, and the other party, I mean your defendant mostly, did not pay the money, defaulted the payment of that particular judgment. So this is the starting point of bankruptcy proceeding. Okay, you must have a judgment first. Okay, subsequently, what you do, okay, you must make a request to the court to issue a bankruptcy notice. All right. Okay, very simple. You must have a bankruptcy notice. This is pursuant to your Rule 89 and also Form 34. This bankruptcy notice is just like one document issued by the court. Open your request, okay, to give a statutory notice to the other party. I mean, the person that you wanted to make bankrupt, okay, so that the person had notified, had been acknowledged by the court and by your good self that he is about to get bankrupt. Okay. A few important issues regarding to this bankruptcy notice would be it will have a short lifespan of 3 months. Okay, this is in pursuant to your Rule 94 insolvency regulation. So at the time I mentioned the regulation, I hope that you have access to this insolvency rule and you have a flip about what is the rule all about. Okay, the duration of the notice is about 3 months. And bankruptcy, you must think in such a way that don't complicate yourself much. Bankruptcy is a proceeding whereby you want to discredit a person socially, you know. That means to say you want to bring down his social credit. So whatever the ruling made by the court or the order granted by the court is quasi penalty in nature. That means it is actually punish the person that default the loan or default the judgment awarded by the court. Okay, because we cannot simply imprison a person or any person that defaulted judgment, correct? The payment of the judgment. So this is how. And we must observe a series of rules in order to make a person bankrupt. This is where all these rules come in. And the bankruptcy notice, unlike your REIT, your REIT, your statement of claim, you can serve by AR registered post. But bankruptcy notice, the court will take a higher threshold. You need to give to the person that you wanted to make bankrupt by hand. Okay, this is called personal service. Okay, personal service. This is pursuant to your Section 3, Sub-Rule 2, Insolvency Act, as well as your Rule 95, Rule 108, Order 62, Rule 5 will be from your rules of court. And then subsequently, you must give affidavit penyampaian. That means to say you have done the service. Okay, this is by virtue of your rules 110 insolvency rule. Okay, in the event that the person did not wanted to receive, because I know, okay, take for example, I am the person that you wanted to make me bankrupt, and I knew that, okay, the notice is from the court and it is with the purpose to make me bankrupt. So what I'll do, I will pretend that I'm not at home. I'll go overseas to spend a long vacation. So in the event of evading the service, then substituted service will set in. So these are the rules pertaining to substituted service, in which it is provided in your Section 3, Sub-Rule 2A of your primary, the Principal Act itself, and your insolvency rules, Rule 109, as well as your practice note. This is pertaining to Nirmala case and also the Asia Motor against the Book Chai case. This is same with the evading service as well as in your REIT when you study civil procedure. Okay. After receiving the what we call the bankruptcy notice, the debtor, I mean the person that owing the money, will have 7 days of grace period in order for them to reply. Okay, they must reply with affidavit. That means they must show that actually they have some set off counterclaim, or there are some issues or the disputes over the bankruptcy notice itself. If not, the act of bankruptcy, okay? Act of bankruptcy, you must refer to your Section 3, Sub-Rule 1. It has got a list from A to J, okay? Except for the provision in Sub-Rule H, it was deleted. But you have a list of act of bankruptcy, This act of bankruptcy is the precondition to be satisfied by the debtor before we can file in a creditor petition. Okay, so far can you all follow me? Okay, this is about the statutory notice only. Statutory notice. Okay, the act of bankruptcy, okay, the most common one will be your Section 3, Rule 1, Sub-Rule A. Okay, so why I say Sub-Rule 3, Sub-Rule 1, Sub-Rule I is the most common one? Because it is based on judgment. Like I have told you from the beginning, all right, what happened is usually Why the debtor was made bankrupt is because after the full trial, you have waited 2 years, for example, for the full trial to ongoing, and then subsequently you get a judgment. But that judgment did not materialize into monetary per se, and it becomes just a paper judgment. That's why your clients will be very angry and will proceed count towards the debtor. Okay, so section 3 subrule I, please bear in mind, this is, you must be very familiarized with this section. And most of the past year exam are testing your knowledge on section 3, rule 1, sub rule I. Okay. So after being served and all that with bankruptcy notice, actually the debtor can file summon in chamber. Okay, this is just like your NASA, your notice of application. But since this is a petition, we call a petition, like divorce petition, this bankruptcy is also undergoing creditor's petition. So we use a different term here. It's called summon in chamber to set aside bankruptcy notice. If, let's say, the debtor failed to do so, okay, the creditor may actually proceed to CP. That means it is a creditor's petition. And you must file the creditor's petition within 6 months of the date where the presentation of act of bankruptcy commence. Because you must realize that bankruptcy is a quasi-penalty award by the judge to punish the defaulter, correct? So whatever time frame, you must comply strictly. Otherwise, the whole proceeding shall be null and void. Okay. So after you file the creditor's petition, you must also serve to the debtor. This is also by the way of personal service. Okay. After you have served the by hand, I mean to the debtor, subsequently you need to let the court know that you have served the copy of creditor petition according to the provision. Okay, this is by virtue of your rule 1110. How do you do that? You file an affidavit penyampaian. Okay, as simple as that. So in the event whereby if the debtor he is evading the services, like I know there's bankruptcy notice already filed on me. Okay, subsequently I defaulted the payment within 7 days, no response. So CP is there already. This is the final step before the court can award bankruptcy order against me, for example. So again, I evade, I try to run away from it. So substituted service come into place whenever there is an effort to evade the service. Okay. So open issuance of this CP, actually the debtor will still have the chance to set aside or show cause against the creditor petition. Okay, so this is by virtue of your rule 17 of your insolvency rules. Okay, please be familiarized with whatever provision that I've told you. Okay, and then subsequently set aside application will be heard by court. Okay, if there is no such thing as this, most of the time in practice, the debtor won't come. He already in a very difficult presumably he's in a very difficult financial difficulty. Usually he defaulted the loan of the bank and he will be nowhere to be found. So usually what this number 6 will hardly happens. And usually the court will give you a hearing date to hear about the creditor's petition, whereby you tender your evidence on that in chamber, and the court can dismiss the CP, stay the CP, or it can allow the creditor petition. Once the creditor petition is allowed, the bankruptcy order will be issued. That means it's already there. The person will be declared as a bankrupt. Okay. So I will need you to understand that the amount that a person can be educated to be bankrupt will be now 100,000. And for the purpose of discussion of past year question, we will just focus on 100,000. I do not personally think that the examiners will confuse you with, past like 2017 and before that, okay, punya question types are. So just remember, the threshold to make a person bankrupt will be 100,000. This is very important as well because there are some questions that will just put down 45,000, which is below the threshold of bankruptcy. So please pay attention, okay? So this is the so-called step-by-step stuff. You must uh, roughly get to know what is it about. So first thing, we request for the issuance of bankruptcy notice. This is in Form 35, Rule 90. So this is what we have filed in the court. Attached together with this request for issue of bankruptcy notice, you must put together with the writ summons, statement of claim, judgment, as well as the proof that you have served the judgment to the debtor, and in which to say the debtor never pay for the judgment. So this is what you find as a first step in the court. Very important. And subsequently, you also need to file yourself actually, but this is by right the one that issue from the court to your good self or to you as a solicitor. This is what we call as bankruptcy notice. Please have a clear understanding. This one, I think, is the most important slide of our class today. You must read this notice ke bankrupt very well. Okay, number one. Okay, ambil perhatian bahawa dalam masa 7 hari. So 7 days must be provided here. Okay, please, very important. Subsequently, all the questions should be evolving around the technical issues of how a bankruptcy proceeding will be commenced. So this one is particularly important. Favorite question. Okay, 7 days. Tidak termasuk dalam hari penyampaian tersebut, and you must pay to the judgment creditor, okay, the alamat, total sum. This one also very, very important because most of the time the question will just put, okay, the sum of RM 100,000 plus interest thereof. Cannot. Like this, it will amount to a technical error in the bankruptcy notice. Thereby, your bankruptcy notice is invalid. Okay, that means people can challenge this bankruptcy notice. So, full amount you must write. Okay, so by which judgment? Okay, which suit? Okay, execution is not stay, and it is must be a final judgment, Okay, pelaksanaan tidak digantung. Okay, ataupun kamu telah menjamin atau compound untuk jumlah kepada kepuasan. That means to say there is no appeal, this is a final judgment and there is no stay with the whole proceeding, the main suit that you have commence against the debtor. The main civil suit is a final judgment. Very important, okay? And then you have to list now, quantify now, whatever your sum owe, okay, inclusive of the interest and also the cost involved, and give a total sum. This total sum must be the same with the total sum that you have mentioned here. And then subsequently, you have to endorse the notice. Okay, endorsement means you must give the other party 7 days to respond. Respond means what? Means they have dispute, they have set up, they have counter claims, they have arguments that the amount is excessive, for example. Okay, this is how it works. Okay, this bankruptcy notice, please have a look after this class learn it by your heart, then I think you can answer any other question in the future. Okay, so this is another example. This is a substituted service application, okay, whereby you also file a saman in chamber. We call saman dalam kamar because this is a petition. Okay, in a civil suit, normal writ action we call notice of application. I think it's almost the same. The format also same, but the wording, the terminology used, you must be a little bit professional because you are answering for CLP. So you must write something like this, someone in chambers. Okay. So this is how you apply as substituted service if there is an issue of evasion of service. And if the person, let's say, did not respond at all after 7 days, okay, within 6 months, okay, please remember, within 6 months, you must file this creditor's petition. We call it petition permuting. So you must state in the name of the who is your pemutang, I mean the who is the creditor here, and apply against who, the debtor, and then subsequently this CP is also being challengeable, if you do not quantify the sum. Okay, but the key words here would be 6 months, very important, 6 months, and then the so-called the debtor did not take within 7 days take any action to challenge the bankruptcy notice. So please bear in mind, this is a creditor petition. I will encourage you all to have a look, and to get familiarized yourself with all this technicality. Okay, and this is also the creditor's petition. Okay, we have 3 pages here. Okay. And finally, after the hearing, the court will issue their bankruptcy order. This is your bankruptcy order lah. Okay. Whatever question, I'll put it at the back to answer lah, because we have plenty of slides to go through. Never mind, you can put. I'll be helping myself to see what are the questions later on. Don't worry. Okay. So next, we talk about how to make a company to be wound up by court order. Actually, there are some ways. I mean, there are voluntary winding up by ways of the directors as well as the creditors. But the favorite question is not focusing on that, I believe, because I've been through 5 years past year question. None of it talk about voluntary winding up, but most of the time they ask you to discuss how to go against the winding up the process order by the court. Okay, so unlike this bankruptcy proceeding, okay, the winding out of the company, you do not need to have a judgment in your good self. I mean, you do not need a judgment. That means to say, you can commence the action without taking a separate. I mean, you before you commence a winding up proceeding, you do not need to take a civil action against that particular company that owe you money. The only criteria that you need is, okay, the company had owe you more than, for the current one, the prescribed value is 50,000. More than 50,000, never pay. Okay, good, very good. You purposely do not want to pay me this 50,000. So I can straight away commence a winding up proceeding against your company. Please bear in mind. Okay. So how do you do that? Number one, it will be sending a notice of demand under Section 466 of Companies Act to the other party. Okay. That means to say, we have to send a notice of demand. This notice of demand is not the same as your bankruptcy notice, whereby you need to file in the court and extract it from the court. This notice under Section 466 has no standardized format. Number one, this one you bear in mind first, okay? No standardized format. You do not need to request it from the court. You are just writing it under your law firm letterhead, and then you send by personal service to the debtor. That means the debtor company that did owe you money. Okay, as simple as that. Okay. After the statutory notice, I mean the letter of demand or the notice of demand, what happened is you wait 21 days. Okay, remember in bankruptcy notice, we wait for 7 days. So in company, because company operation sometimes could be different and it involves hierarchies in making the decision. You must think in that way lah. So it is granted with a longer duration to satisfy the debt. For example, you can say, okay, I owe you 50,000. Okay, now I pay you 30,000 first. So I will not get winding up. But you have to give me time. 7 days is not enough for a company to make decision sometimes. All right. Depends on the size of the company. Okay, so the court had granted 21 days of grace period for the company to pay the debt. Okay. But in most of the case, the company still default after 21 days. So what you can do, you can file a winding up petition in the court, and subsequently, as usual, any petition must be served to the company. Okay, please remember that whatever you have any filing in the court. This is a standard rules. You have a filing in the court, then it is your duty to let the other party know. You cannot just file a petition. You cannot file a notice of application without informing the opposing party. It will not be fair. So this is what is it about. Subsequently, what you do, okay, after the service, okay, you file in your affidavit penyampaian to show to the court that, okay, I have duly served this winding up petition to the other party, as well as to the SSM, as well as to the Director General of Insolvency. You must serve as three parties. So these are my proof. Okay, I have taken the photo and the person had acknowledged my serving of petition. So you file everything into the court. Subsequently, be 7 days before the hearing of winding up petition, you must advertise the petition. The winding up petition itself, you must advertise in 2 local newspaper as well as the Gazette, the Warta Kerajaan. Okay. After you have done so, okay, the registrar of the court, the penolong kanan or timbalan pendaftar, they will grant you a registrar certificate to say that you have compliant to all the rules as above. You have filed everything, like you have done the newspaper thing, you have done the service, okay, everything is okay. Then only the court will hear your matter. Okay, so during the what we call the hearing, the court order shall be made, as simple as that. And then the assets of the company will go to the liquidator. Okay, liquidator is a formal term. Okay, so liquidator will be just like serving the purpose of the DGI or your previously called official assignee, or the adjudication or receiving officer. So same. So the liquidator will take over whatever the properties, the assets of the company, and subsequently divide to the creditors based on their rank lah. I mean, whether you are in the secure creditor list, preferential creditors, or unsecured creditors. So I will need your I will need your attention on section 465 as well as section 466. So these are the main legislation that you can make a company to wind up. So you please have a look. The usual one will be your 465 sub-rule 1, sub-rule E. That means the company is unable to pay the debts. Okay. So an inability to pay the debts is provided under section 466 sub-rule 1, sub-rule A. Okay. In our question, we'll elaborate further, but it's good that if you have time to have a look at this statute provisions for your better understanding. So like I said, the winding up procedure, you do not need to start with a judgment, okay? You can just start like this, a letter of demand. We call it section 466 sub-rule 1 notice, okay? This is a statutory notice. It's actually just a letter of demand. Under our firm's letterhead, and then you can issue the demand, how much you owe, okay, pursuant to section so and so, what is the amount of money that you have owed. And please and further take notice that the event that of your failure within 3 weeks from the date of service of this notice, if you are still unable to pay, okay, the winding up proceeding will be instituted against you without further notice. So grace period 21 days. These are the compulsory content that must have in your section 466 notice. Okay? Remember that. And subsequently, I think you need to file a surat akuan that you have actually gave the statutory notice to the company. So as we can compare, to bankrupt an individual is relatively harder as compared to make a company to wind up. Reason being, company is a separate legal entity. It goes winding up, bungkus lah, gulung. It will not impact the directors and also shareholders involved. The shareholders, the directors can still walk freehand. So this is the difference. Okay, so this one is relatively easier. Okay. So if 21 days still the companies did not have any response, you have served, you have given them, then what you can do is you can present your winding up petition. Okay, so the proper terminology to be used here will be winding up petition. After the 21 days grace period, the debtor company did not respond at all, didn't bother, do not have any intention to pay the debt. Okay, fine. We issue the winding up petition. Bring the company to the court. Okay, so petition wise, you also need to quantify. Okay, quantify what are the sum owed, and the sum owed must be, like I said, the prescribed value nowadays is 50,000. Okay, just remember that, and you must state that you have duly served the statutory notice of demand. Okay, which date, but no response. 21 days have been over. So, okay, you serve everything. And then what are your prayers? Okay, penggulungan. You want it to be wound up by the court, and a liquidator to be appointed by the court to dispose or to divide the company's asset. Okay, as simple as that. So these are the what we call the winding up petition. Okay, just be a bit familiarized with the technical thing. Okay, and then after you have filed the so-called the company winding up petition, it is very important because I said to you, it's relatively easier to make a company to be wound up by the court because you do not need a so-called judgment. You just the company owe you more than 50,000, then it's your right to demand. And then if not paying within 21 days, then you can commence a winding up petition. So relatively, it will be easier. But how do we make sure that there is a counter check mechanism inside the court to prevent malicious prosecution? Take, for example, if I and you, okay, I am Qi Huiping's company and Sendirian Berhad, and you are ABC Sendirian Berhad, and we are rivals as well as we have some trading, okay, in the business world. So whenever I have cumulative debt around 60,000, because more than 50,000, isn't it? 60,000. I simply file this winding up petition to kacau your business, to disturb and harass your business. Can I? Okay, actually, a lot of people did that in practice. So this will be subjected to this affidavit verifying the petition. So whatever the person, for example, I want to kacau you, I must file in an affidavit to prove my good faith. Not that I simply wanted to disturb you or to harass you for malicious intention. Okay, so you must give in this this affidavit verifying petition. This is also pursuant to your Rule 26 company winding up rules. So you have to memorize some. This one is not provided during examination. Okay, and then you must serve the company winding up petition to all three parties. Okay, first it will be your doctor company. Okay, second your SSM, alert SSM lah. And then third will be your Director General of Insolvency. Okay, so this one is also pursuant to your Rule 25. So after serving, you have to give a affidavit penyampaian. That means to show proof that you have done the service. Like I said to you, any petition that you file in the court must be acknowledged to the opposing party. Okay, please bear in mind. Okay, so these are the example of the service and affidavit. Okay, after that, what do you do? After you have served the petition, still no response. I mean, the debtor company did not show cause or did not actually file an affidavit or someone in chamber to set aside this petition. Okay, what you need to do next, you must advertise. Okay, you must advertise in Gazette as well as two local newspaper. Gazette means Warta Kerajaan Persekutuan. Okay, so you must advertise the winding up petition. Okay, to claim that, okay, I already notify you, not just by personal service, but also I have make it public. Okay, because companies winding up sometimes is a society issue. Okay, because companies can have borrowing elsewhere. People will need to know whether the status of this company is worth investing or not. Okay, worth borrowing or not, worth future dealing or not. So this is how we do lah. Okay, you advertise. Okay, and after you have complete the steps of advertising, uh, okay, then you can request the registrar, the penolong kanan pendaftar lah, or timbalan pendaftar with the High Court, okay, to issue this registrar certificate. This is pursuant to your Rule 32 of companies winding up rules. Okay, so this registrar certificate, please have a look at the requirements A to your what we call E. So that means the pemutant, the petitioner had already duly, the petition itself had been duly gazetted as well as being advertised in two local newspaper, and subsequently there is affidavit verifying the petition itself. Service, the affidavit of service penyampaian is also there, and then the what we call the petition is not nominating its own liquidator. So, subject to the court appointment, as well as the rules of the petition, the winding up petition had been duly compliant. And some of the time you no, not some of the time, all the time you need to pay a sum of deposit to the court, lah, okay, to the court as well to cover the cost of appointing a official receiver later. Okay. So after that, it will be like hearing, isn't it? Okay, it will be like hearing. Before the hearing, you need to let the court know who are the personnel that wanted to attend this hearing. So this is the notice of intention to appear in the hearing. You cannot simply go, because the companies, for example, the opposing, the debtor companies, it will consist of multiple directors, secretaries, as well as the manager, whosoever, the legal personnel or legal officers of that companies. You must let the court know who intend to appear for that winding up hearing. Otherwise, the court will be full of people, right? So you must give a list, subject to the approval of court. And the court during the hearing will actually grant the order for the winding up or dismiss. Okay, so this is the sample of court order for winding up of a company. So after winding up, you also need to take one more step to advertise in two local newspaper, as well as you must advertise one more time in the Gazette some more. And then you must serve this to your liquidator. Okay, the judgment, everything lah. Okay, so a little bit on the prescribed value on company winding up. If you cannot remember that much, just remember 50,000 as well as your 21 days of grace period, because these are the common questions that they are going to test you during the examination. All right. So far, are we good? If you are good to go, then we'll look at the question. Okay, we'll start from question professional paper 2019.
Can I ask
Uh,
question?
yeah. Who is that?
Here, Joshua here.
Mr. Joshua. Yes.
Okay. You said we submit. We will submit the petition first, right? To start the proceeding, we will send the 466 notice, right?
That is for company winding up,
Company
is it?
winding up.
Yes.
Okay, right. Okay. So what happens if the company comes and says that
Pay the debt.
no, they say, okay, I would like to litigate the matter. So does the 466
No,
stop?
you cannot.
Oh.
Okay, the thing is, you do not need to litigate. You do not need to get a judgment, all right, for the what we call for the debt. So all you need to do is you must prove to the court that the company is indebted to you 50,000 or more, and it is suffering from this sort of commercial insolvency. That means they are not able to pay the debt. You do not
dispute the claim, if they dispute the claim,
they dispute the claim, it can goes on during the hearing or during the what we call during the hearing lah. During the hearing.
so that means
Yes.
when you send the 21 days, after the 21 days, there will be a hearing, correct?
After the 21 days, you must realize that there will not be hearing yet. There will be subsequently, you have to file a petition, the winding up petition. You must also advertise and you must get a lot of procedures, as you can follow from my steps here.
Yeah, just
Then
now.
only the court will grant the hearing at last.
So that means the company cannot come and do anything until you do all the steps, correct?
Unless you have settled the claim.
Earlier
You cannot just what we call, you cannot just come and dispute. Oh, I have disputed the claim. I send you back a letter, something like that. No.
Cannot. Oh, okay.
Cannot. But the bankruptcy can. Winding up cannot. Winding up a lot of malicious prosecution. This is the reason because it's very easy. You get what I mean? It's relatively easier.
So when we send the notice, either they pay or don't pay. If they pay, then the matter settled. If they don't pay, we
Yes.
proceed with all the steps.
Yes, you have to proceed with winding up
Or-
petition.
So they cannot stop us halfway, say
No,
that
no,
I don't agree
no.
with the debt or something like that.
Yes, 21 days is their chance, final chance to pay you. If they do not pay, I'm sorry, we have to file. Okay, the steps is the statutory provision here, you must distinguish yourself from bankruptcy proceeding. The bankruptcy proceeding for individual, we already filed inside the court, for our bankruptcy notice, This one, the notice is just a letter of demand, No doubt it is a statutory demand, but this is just a paper from the law firm to you in order for you to respond within 21 days. You get me?
Understood. Understood.
Okay, so we are good to proceed. Okay, so we'll look at the question now. Okay, James is a successful businessman. He owns many companies. So what he did is they are all doing well. In 2017, James set up a company. It's called Malaysian Vegetable Sendirian Berhad. It supplies vegetables to supermarkets across the country. And James actually owns 95% of the shares in the company, and he's the MD, managing director. The other shareholder and director is his son, okay, Dumbo. So James had already paid 3 million cash, okay, to the company as working capital. That means to say the paid up capital of that company is 3 million. Quite a rich company, eh? See what happened next. He borrowed a further 3 million from lender bank, the bank. Okay, the company agreed to repay 100K per month to the bank for 36 months, and business had been excellent, so no problem yet. The company had received orders and deposits from 400 supermarkets across the country. The current net assets of the company are worth 10 million ringgit. Okay, so current asset is there, 10 million. So further, there are fixed deposits exceeding the sum of 3 million from last year's profit alone. Okay, fixed deposit, also not bad, but this is locked in the fixed deposit. The companies expects to make a further 4 million ringgit after tax profits this year. So demand for fresh vegetables is growing. James need to find a new vegetable suppliers. So James, what he did, he traveled to different part of Asia to get all these long-term supplies. So in the last 4 months, he had been away in Vietnam. He had been looking for a new Vietnamese vegetable supplier. So before James away, he placed the company in the hands of his son, Dumbo. So Dumbo, as the name had already suggested, not very smart guy, he gave strict instructions to Dumbo to ensure that all liabilities, especially the loan repayment to lender bank, must be paid off. So Dumbo disobeyed James' instruction. He had not made repayments to the bank. So the bank manager numerous attempts to communicate with James Dumbo, but failed. Dumbo is too busy with his own affairs, apparently be partying. Okay, so the bank has served notice of demand under section 46501E. That means the company is unable to pay the debt. Okay, so the notice has been served at the registrar office of the company. So the service is all right, as we have learned from our chart just now. And the notice demands repayment of all outstanding sum within 21 days. So this is the keywords here. What does it mean by outstanding sum? The notice further says that if the company does not pay the sum of 1.8 million within 21 days after service of demand, the bank will file a winding up petition against the company. The company staff had been waiting for Dumbo to give them instruction, but he's still very busy with the parties and did not even answer calls. So Dumbo did nothing to pay the debts. Okay. So after serving the notice, okay, the bank filed a winding up petition against it, like we have just discussed. It did nothing to settle the debts. So James returned last week from Vietnam. To his horror, so he felt horrified already. He feel very scared because his company is so rich, 10 million plus 3 million upcoming profit, 4 million is going to wind up just for the 1.8 million. So what he take as an effort with a check for 1.8 million, James rushed to the bank and offers it to bank manager. The bank manager said the bank's board is quite unhappy with the company's lackadaisical attitude. That means the company did not bother because under Dumbo's management, they didn't bother to answer phone, everything. It could have annoyed the management of the bank. So the bank took it personally. Okay, the matter is already in the hands of our solicitors. My instructions are to continue with the petition to wind up the company. I'm sorry, James. Business is business. This is quite common in the practice. Even though the companies can pay, but I want to winds you up. Okay, so the winding up petition comes up for hearing in a month, so you still have time. The board through James seeks your professional help. So the question advise the company how to oppose this winding up petition, what procedure the company comply with. So we must go back to the flow chart again. Okay, so the issue roughly we know already. Okay, I'll not repeat for the sake of wiser time management. So, okay, where are we? We are here, right? We are at the hearing now. 1 month after today, it will be a hearing for winding up petition. So how we want to help this Malaysian vegetable Sendirian Berhad? So this is my suggested answer. If you are quite blank about what to write, when you are in the exam mode, my advice to you is in regards to CPC, I mean the criminal procedure, rules of court, everything same. You make your first sentence reference is made to Companies Act 2016, then you put a mark here, CA 2016, and Companies Winding Up Rules 1972. CWUR 1972. Okay, it will save a lot of your time later. Okay, if you are very blank about what to do, okay, from the beginning, you can use this trick. So I will put my introduction in such a way. Lender Bank had commenced the winding up proceeding by court on the grounds that Malaysian Vegetable Sendirian Berhad, I'll put the company was unable to pay its debt. This is straight away I copy from section 465 subrule 1 subrule E as per the question. Okay, so usually this is my style. I will make a introduction according to the facts extracted. Okay, the definition of inability to pay its debt was actually enshrined or provided in section 466 subrule 1A in the given scenario. You do not need to copy down the whole provision. Just fit in the facts, the current facts. And it was suggested that the company had defaulted the payment of loan amounted to 3 million ringgit, and lender bank had demanded the repayment of sum of 1.8 million from the company. The said sum was exceeding the amount prescribed by the minister. I'll put here, i.e., 50,000 at material time. Okay, 50,000. I don't want to confuse you all. So what I'll do is I'll put 100,000 for bankruptcy as well as 50,000 for winding up procedure. Okay, hope it's clear. And I will use one case to support Malayan plant against Moscow Naroni Bank Limited. Okay, to say that the test of inability to pay debts is that of commercial insolvency. That means to say the cash flow of the company is tight. Yes, I agree. You may have a lot of assets, but where is the cash to pay the current debt? Okay, if you do not have adequate cash, yes, you can have a few shop lots or even a factory. for your vegetable supply, but you do not have the cash to meet the current debt, then you are commercially insolvent. Okay, please remember that. Apparently, the company did not respond or pay the sum within 21 days, where the service of Section 466 notice was proper. It was presumed that the company was unable to pay its debt. True enough, because they did not, the Dumbo is the culprit here. So Dumbo did not respond accordingly due to his involvement in a lot of dancing parties, etc. So subsequently, winding up proceeding was commenced against the company. So at this moment of time, we have made the things quite clear, and now we must turn our discussion of the question how to help the company, because you are expected to behave like a lawyer. You must advise your client. So how do we go about that? To oppose the winding up petition, the company could raise the following issues. These are what I have identified. All right. So I was first comments that no judgment obtained, but there is no statutory requirement. Okay, like I have said to you all from the start, there's no statutory requirement that a judgment is needed before a winding up action can be commenced. So this is not a ground to post. So I dispose it. All right. So second, I will mention about the issue of liquidated sum in Section 466 notice. Apparently, the lender bank punya the letter of demand, the notice of demand state outstanding sum and or owe 1.8 million ringgit to be settled within 21 days. So I do not know which and which. I feel there is a what we call uncertainty, ambiguity in this term. So I will set it as a ground for opposing. Okay. So I will further make my stand that there is no formal requirement of the format pursuant to Section 466 notice, but liquidated sum must be clearly stated. This is based on one case law, Ng Ai Kwai against Taikip Enterprise. So I will further conclude that such ambiguity and uncertainty in the indebted sum could be a ground for opposing the winding up petition. Other than that, it seems that the grace period 21 days, okay, the bank already give you. It was Dumbo that did not obey the 21 days, so no issue. Service also to the registrar office, no issue. Okay, so this is how I'll put my sentences. And then subsequently, I will put according to the flow chart that we have discussed. Okay, so no advertisement because the facts is silent. So you have to raise this issue. So because otherwise you cannot get the certificate of compliance from registrar. So I will put the bank did not advertise accordingly, and the facts had mentioned that the hearing of the petition with 1 month time. Actually, the requirement is only 7 days before the hearing. But I will further submit so that I read the question properly. I'll do what? I will say that should it not to be done, should it be not done, the bank could not acquire a certificate of compliance from registrar, which is pursuant to your rules 32, the company's winding up rule. Okay, but Bank Utama against GKM provides that failure to advertise is not fatal, and it could be curable under Rule 193 and Rule 194. That means to say, even though the bank did not advertise, subsequently, it can make the advertisement later. Okay, so this is what it means by curability. Okay, and ability to settle the debt. I think this is most important here. Okay, the company is advised that the test for inability to pay is that of commercial insolvency. Again, I repeat myself, in which the company can be insolvent and wealthy at the same time. Because you look back at your question, it provides you with the payout capital 3 million, it has got 10 million assets, it has future earning of 4 million, fixed deposit 3 million. So relatively, if you look at the only 1.8 million, so you must say something about this, Like I say, I have told you, the company could be commercially insolvent if there's no current assets available to meet its current liabilities. That means a lot of people have told in the business world, the cash flow cash flow got problem. Okay, it may be wound up. So this is also a position in Sri Hatama's development against MBF Finance. So relating to the scenario given, it is obvious that the company is commercially solvent. Why I said so? As through its managing director, James was able to pay 1.8 million as a lump sum. Okay, you can further elaborate perhaps with his check. Okay, so that means to say the companies can pay. Why we need to go to winding up petition in the first place? Takana is because of the poor attitude by the companies that you should wind it up, isn't it? We don't care for these attitude problems, isn't so? So this is a good ground to oppose the winding up petition. So I will further submit because the last sentence they put 2 paragraphs, what the bank manager said. I will put it in my affidavit to say that this is a malicious prosecution or abuse process of court on part of lender. So I will say what, despite knowing that the company is solvent, because apparently this what we call the company can actually pay through James, is managing director. But lender bank has still proceeded to winding up petition on the ground of company's lackadaisical attitude. There was a clear malicious intention and abuse process of court on part of lender bank in this issue. So in opposing affidavit, you can write that. Okay, so I rely on one case, Nadi Bumi Resources Sendirian Berhad against UI Lead Sendirian Berhad. So I submit that based on the reason that we have discussed, the company can pay the debt, and this is just an abuse process of court. The company can successfully oppose the winding up for petition. Okay, so put a firm conclusion here. Okay, and B. So what are the question B? So this is very common, when you finish answering the answers A, you forgot about what is the question of B. So what procedure should the company comply with? So I will put myself, okay, because we are at the stage of hearing, 1 month before hearing. So what I'll do is the company should file an affidavit in opposition at least 7 days before hearing and serve on the petitioner. That means the lender bank or the solicitor in charge, because they said they are in the hands of solicitor. Okay, so this is by virtue of Rule 30. Okay, CWUR. You just memorize one case. Don't have to go through so many cases. Just memorize one key case that can cover every single rules under the earth. It will be a better solution for you. Okay. Or what I think, because the hearing will be there, so you can actually file an injunction to stop the winding up proceeding. So this is pursuant to your rules of court, Order 29, and also Mobicon case. Okay, so I plead in alternative, but judging that the marks is only 3, so probably the first paragraph will be sufficient. Okay. So please allow me to proceed a little bit fast, otherwise we'll be running out of time. Okay, so this is PP question 2019 supplementary paper question 8. So Aman is a chef. He runs a chain of 20 Balinese restaurants across the Klang Valley under the name of a company called Bali Isti Rehat Sendirian Berhad. So this is a company. The restaurant business is exceedingly successful. One day, some patrons came to see Ahmad. So they're from Perak. They tell him how good the food is. They beg him to open Bali Istirahat branch in Perak. So the company subsequently branched out. They opened 5 new restaurants at Ipoh alone. The company needed some money for the operation expenditure for Perak restaurant. So the company borrowed 100K, 100K from Bangkok Bank. Okay, Bangkok Bank. So as security for loan, Ahmad signed a personal guarantee. So there is an issue of Ahmad as other guarantor here. So he's not a social guarantor, but his guarantee for his own business. So we call it other guarantor here. Right? So if the company ever defaulted, the guarantee required Ahmad to pay the bank all sums outstanding at the time of default. The company made regular repayments to the bank. As he lived in KL, Ahmad was compelled to travel to Ipoh at least twice a week. In this way, he ensured Perak business had his personal touch. So what happened? Last year, Ahmad fell ill and he was no longer to travel to Ipoh. So due to his absence, the business in Ipoh crashed. So the company could not keep up the repayments to the bank. It defaulted monthly installment. So bank sent demand to Ahmad, okay? Demand to Ahmad as a guarantor, as other guarantor here to pay outstanding sum. In the demands, bank solicitor stated a sum of 45K was outstanding from the company. And Ahmad was so ill, he paid no attention to the demand. So demand already sent. So the bank sued Ahmad as guarantor. See here, they obtained a judgment already. So we can rely on section 31I, the AI, the 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 popular of bankruptcy. Judgment, defaulted payment. This is the ground for act of bankruptcy here. So what is said in the judgment, shall pay the judgment sum of 45,000 to Bangkok Baht, interest at the rate 5% per annum, and the judgment sum until full satisfaction and legal costs. So no quantified amount. That means tak ada butiran, and the total amount was not given out properly. So this was on December 2018, and Ahmad did not make any payment towards the judgment sum. So on 5th January, the bank served the bankruptcy notice on Ahmad. The bankruptcy demands Ahmad to pay Bangkok Berhad a sum of 45,000. You see, still not quantified, plus cost, interest rate, etc. Okay, again, as Ahmad was ill, he did nothing. So probably 7 days would have lapsed. Okay, now you see, on 5th of November 2019, the bank solicitor served Ahmad a creditor's petition. The petition dated the day before, 4th November 2019. Okay, the creditor's petition states that Ahmad, again, you see, 45K plus cost plus interest, everything. So continuing, Ahmad had come to see you for professional advice. So advise Ahmad whether bankruptcy notice is valid or not. And B, advise Ahmad on what grounds he could challenge the creditor's petition and state the procedure that you intend to oppose the creditor's petition. So what I'll submit here, okay. Answer for A, okay, the facts suggested that the Bangkok Bank had commenced bankruptcy proceeding on against Ahmad on the ground pursuant to Section 3, Subrule 1, Subrule I. Okay, so this is what we have discussed earlier based on the final judgment, judgment not stay. Okay, so the amount must be also quantified. Okay, so to challenge the validity of the bankruptcy notice, Ahmad is advised on the following issues. So first thing you must look at will be Ahmad is guarantor other than social guarantor. So where you can find this provision is in your section 5 sub rule 3 sub rule B. Okay, A provide for social guarantor and B provide for other guarantor, guarantor other than social guarantor. Okay, in furtherance, you can find your social guarantor in the section 2 of Insolvency Act itself. Okay, that means a person that guarantee for loan, scholarship, for non-commercial purpose, everything we call it social guarantor. But Ahmad was not the case here. Ahmad was set other guarantor, in which he had made personal guarantee for Bali Isti Rehat Sendirian Berhad in order to secure the loan. So I will say section 5, sub-rule 3, sub-rule B, Insolvency Act, Bank must obtain leave of court prior of commencing bankruptcy action against Ahmad. In furtherance, it does not appear that Bank had exhausted all modes of execution. Okay, we do not see the facts that the bank took any action against Bali Isti Rehat here, correct? Including winding up against the borrower, take his assets, whatsoever. It's all mentioning on Ahmad's judgment and then subsequently serve BN, etc. So, okay, I will use my section 5, sub-rule 4 and sub-rule 6 here to go against it because it does not exhaust all the mode of executions against Isti Rehat by right. Isti Rehat was a borrower. The Ahmad was just a mere other guarantor. So you cannot just straight away attack Ahmad. No doubt Ahmad is the director of the company. Okay, so I will say that therefore the bankruptcy notice would be null and void on this ground. I use the case of Hong Leong Bank against Ong Mun. Okay, and then subsequently, this 7 days for Ahmad to settle the debt. Okay, the BN issue also did not contain 7 days grace period because if you flip through the question, it only provides the 45,000, the interest, and also legal clause, etc. But it does not provide 7 days. Okay, this one is a very serious infringement of section 3, sub-rule 1, sub-rule I. That's why you have to be very, very familiarized with this long provision. Okay, 7 days is codified here. Okay, and I will held that the bankruptcy notice is invalid for this ground. Okay, as furtherance, there is no quantified sum. Instead of total amount of debt, just now I've shown you guys what exactly the bankruptcy notice looks like pursuant to your Form 34. So it must contain exact amount, not something like this, vague information as quoted. We quote from the question. Okay, the judgment sum of 45,000 interest rate, okay, to be assessed. You may not need to copy down all the sentences as long as that you have shown to the examiners of your sufficient understanding about what you are talking about. Okay, the exact sum was not stated in the end. So pursuant again, you have infringed this section 3, sub-rule 1, sub-rule I, Insolvency Act. The said interest must be quantified up to date, okay, of issuance of bankruptcy notice, and it render it to be defective and non-curable. So Fauzia Osman against BBMB. So whatever that touch the root of section 3, sub-rule 1, sub-rule I, that is jurisdictional matter already. You cannot cure. Okay, you cannot cure. Okay, please understand that. So based on the aforesaid arguments, it is submitted that BN is invalid. So this is how I'll oppose it. Okay. Subsequently, because he's ill, isn't it? So he did not take the time to set aside the so-called the bankruptcy notice. So the Bank already proceed into the creditor's petition. So the question B require you to challenge on creditor's petition. Okay, so you must say again, guarantor other than social guarantor. So you may not need to repeat the whole thing. Okay, I will put myself in such a position. I said, as discussed in question 8A, the same reasonings were reiterated. Okay, I repeat myself lah. Okay, pursuant to section 5 sub rule 7, okay, Insolvency Act, CP, the creditor's petition will be null and void for the non-compliance on part of bank pursuant to section 5 sub rule 3B, that is other guarantor, and 5, 4, and 6 of the Principal Act. That means he did not exhausted all the mode of execution against Bali Isti Rehat Sendirian Berhad. So same ground, you can dismiss the CP. Okay. So again, if you notice the date, okay, the bankruptcy notice was served on Ahmad on 1st January, but did not respond because he was sick. So L bankruptcy was deemed to have committed 7 days. That will be 8th of January 2019. So according to section 5 sub rule 1 sub rule C, remember we have discussed the CP must be presented to Ahmad within 6 months from the date of act of bankruptcy was committed, But this CP issue went in November. Okay, November. That means already how many months? 10 months, So on this ground, the CP will be nullified and it will become invalid. All right. And then subsequently, like I've discussed to you, I will use the prescribed value of 100K for individual bankruptcy, not to confuse you all with the years. So you just memorize for this coming exam 100,000. So I'll use the same here and I'll say that it is lower than the prescribed amount pursuant to section 5 sub rule 1 sub rule A. Please use the appropriate provision. It's all inside. You just have to flip through. Therefore, I said that the creditor's petition is defective. Okay, liquidated sum. The sum was not quantifying the interest and legal fees in exact amount. Again, it infringed section 5 sub rule 1 sub rule B and rendering CP to be defective. So what Ahmad can do, Ahmad is advised to set aside because now BN already there, is already creditor's petition, You can only use one provision, that is rule 70, to set aside that CP by summon in chambers supported by affidavit. Affidavit just said whatever grounds that we have mentioned above. And the court will fix a separate hearing for application to set aside. That means before the hearing of creditor's petition, should Ahmad come to the court and present himself with summon of chambers and also affidavit, the court will hear that application to set aside first. Okay? All right. So question 2020 main question B, question 8, sorry. So XYZ actually took a loan of 2.5 million from ABC Bank to purchase a piece of land to build its new factory. Okay, so XYZ Sendirian Berhad's principal business was to build vehicle components for export to Southeast Asian countries. As security for a loan, XYZ created a charge under National Land Code over the said land in favor of ABC Land. So XYZ borrow loan 2.5 million from ABC. So as security, okay, they put a charge over the land to ABC Bank. So additionally, an irrevocable power of attorney was also executed by XYZ in favor of ABC Bank. At the same time, Z and N who were directors of XYZ, executed a joint and several guarantee in favor of ABC Bank, guaranteeing the repayment of the said loan. Again, Z and N here were other guarantors, okay, because they are not social guarantor. They want commercial loan on behalf of XYZ, Sendirian Berhad, their company, okay. So XYZ, again, defaulted repayment of 2.5 million loan, quite a lot, which resulted in ABC Bank filing a civil suit in Ipoh High Court and obtained summary judgment in the sum of 1.2 million with interest as per the terms of loan agreement against XYZ. So in question pertaining to insolvency and winding up, please pay note, take note. Usually they'll trick you in the sum with interest, not a total amount. Okay. So against XYZ Sdn Bhd as well as Z and N. So together they sue everybody. So XYZ, Z and N file an appeal. So this is not a final judgment. Please remember that. Okay, against the decision of Ipoh High Court in allowing ABC Bank summary judgment. So thereafter, ABC Bank, based on the summary judgment, issue a statutory demand on 1st December 2019, pursuant to this is your section 466 notice. They get notice already, just like a letter of demand. So in the said notice, ABC Bank only demanded XYZ Bank to pay 1.2 million without taking into account of the interest due and owing as 1 of December 2019. So XYZ still failed to respond to the said statutory demand despite the same being served in accordance with the provisions of Company Act. That means the service has no problem. Only thing is XYZ did not respond within how many days? Can still remember? 21 days, okay, 21 days. So ABC Bank then initiated a winding up proceedings against XYZ Sdn Bhd on 1st May 2020. But XYZ Bank did XYZ Sdn Bhd did not file affidavit to oppose it within the prescribed time. But on the morning of hearing of the winding up, the solicitor for XYZ informed the court that affidavit in opposition to the winding up by XYZ was filed and served on ABC's bank solicitor. Can like that, okay? On the morning itself, we will see our answer later. The winding up court allowed the objection. Of course, the other parties are not very happy with this sort of not so ethical attitude. Last minute only you file the affidavit in opposition to others. So ABC Bank's solicitor, the court agreed with the objection of ABC's solicitor and struck out XYZ's affidavit in opposition. Therefore, proceed to wind up XYZ. So XYZ would not. So ABC filed foreclosure proceedings. Okay, to forecloses said piece of land that was charged to ABC Bank without leave of winding up court. That means to say, winding up order given, granted to XYZ, but ABC Bank still go to proceed for order for sale because remember he got one land was charged in favor of that 2.5 million loan. So first party legal charge is there. So, and what he did, the ABC Bank later also filed a bankruptcy proceeding against both Z and N. So question A, XYZ wish to appeal against the winding up order. In your opinion, advising ABC Bank on whether XYZ will succeed in its appeal. Okay, so it wants to go for appeal, Okay, so we'll discuss. So these are the issues that I've highlighted to you a little bit. Okay, so this is my suggested answer. Okay, ABC Bank had actually commenced the winding up proceeding by the court. Again, I'll copy down. Okay, section 465, subrule 1E, Company Act. unable to pay the debt. So again, this is my favorite introduction. The definition of inability to pay is that provided in section 466 sub-rule 1 sub-rule A. In the given scenario, it was suggested that XYZ had defaulted the payment of loan amounted to 2.5 million, and ABC Bank had obtained a summary judgment in the sum of 1.2 million with interest. The said sum was exceeding the amount prescribed by the minister, 50,000 at material time. So again, for the examination purpose, I will not be bothered with the time. I'll just straight away put 50,000 universally. All right. So again, I'll use the favorite case of mine, Malayan Plant against Moscow Naroni Bank Limited, provides that the test of inability to pay debts is that of commercial insolvency. Okay, I have made an explanation towards what does it mean. Okay, and apparently XYZ had not responded or paid the sum within 21 days, where service of section 466 notice. Okay, you can also use statutory notice of demand. It's up to you, but my choice would be I will use section 466 notice. Okay, and subsequently, winding up proceeding was held and XYZ was ordered by the court to wind up. To appeal for the winding up orders, so XYZ could raise the following issues. So this is how I draft my answer. Okay. Number one is the debt is still disputed on substantial ground or abuse of process. Okay, so I will put myself in a position that since XYZ had actually appealed against the decision of Ipoh High Court pertaining to this summary judgment, the said judgment is disputable. You must remember, summary judgment, the other parties had no defense or that is had entered appearance, but then but you have appealed. That means to say the judgment itself is not considered a final one, because there are some issues that raised by XYZ. So I will put down here further, despite there's no statutory requirement for judgment to be obtained before commencing winding up proceeding. Okay, as I already told, the test is XYZ is unable to pay debt. However, XYZ may have good faith to dispute on substantial grounds on the debt's amount. Okay, that's why they appeal. Okay, I will put my stand relating to the action that XYZ had actually appealed is because they have dispute on the summary judgment awarded by the Ipoh High Court. Okay, again, I'll use Nadi Bumi resources and I submit that if there is disputable debt, it could amount to good ground of appeal. Okay, I'll put here first. So again, interest not quantified. Failure to quantify the interest on judgment sum by ABC Bank, okay, in the S466 notice, actually will not invalidate it, So, and this is the case used, YPJE Consultancy Services against Heller Factoring, and XYZ could not rely this ground for appeal. Okay, even though they did not put in the judgment sum, they just put in 1.8 without the interest, can. No problem. Okay, no problem at all. As long as it is more than the 50,000 prescribed amount by the minister. So again, service and technical irregularity of notice. Is there any? So on the fact, it was told that the service of notice and the grace period of 21 days were duly compliant by ABC Bank. So no ground for appeal. Okay, because the question asks you whether XYZ has valid grounds of appeal or not. So you must rule out one by one, okay, to be systematic. Otherwise, a lot of marks is there. You must be systematic in your answer, okay? And failure to advertise in newspaper, okay? So pursuant to Rule 24 and also NKM Holdings, ABC shall advertise in 2 local newspaper, 1 gazette, 7 days before the hearing. The fact was silent on this issue, so you must be able to pick up from the flow chart that I show you. This is compulsory, otherwise you cannot get the registrar certificate pursuant to Rule 32. However, Like I said, this is curable. Okay, as in the case of Bank Utama. Okay, is curable. So no ground to appeal for this. Okay, and serving affidavit on morning of hearing, because XYZ made a hoo-ha, isn't it, on the day of hearing. So vice solicitor serve to the bank solicitor as well as the court lah, on the morning of hearing. Like that. So use the Rule 30 company winding up rule, provides that XYZ may oppose the petition and file and serve affidavit in opposition, actually 7 days before the hearing. You use a case of Affin Finance against APMG Management. Okay, the requirement of filing affidavit in opposition within the time frame is mandatory requirement. So this is also the position of law in Gulf Business Construction against extra holding. Therefore, the court was right in striking out XYZ's affidavit in opposition. They don't care whether you have merit or not, because you do not follow this technical requirement. You did not file 7 days before the hearing. So the court is right. So you cannot argue back, oh, actually I have put in a lot of merits inside my affidavit. The court did not bother with my late submission. You cannot rely on this ground. Okay. So no leave of court obtained prior to foreclosure proceeding. Can it be a ground also? So section 471 Companies Act provide when winding up had been ordered by the court and liquidator had been obtained, actually before you go for foreclosure of that land, you must obtain leave of court. So I will submit that ABC had not followed section 471 Companies Act. So please make use and try to detect problems from every sentences the question gave you. Okay, there's sure going to be a little bit of problems. Okay, otherwise they wouldn't even type it out, the facts like that. Okay, so what is my submission? Whether can appeal or not, that's the main question that you need to answer, isn't it? So I will use the case of Carlson White, Malaysia, provides that the proper remedy against a winding up order is to exhaust the provision under section 470 or section 471, okay, to stay the winding up order rather than appealing. Only on the failure to obtain a stay order, the company can appeal against the winding up order. That means to say the appeal, you cannot simply appeal. Okay, you have to obtain stay first. Okay, pursuant to your section 470 as well as your section 471. So I will submit. Therefore, it will be best for XYZ to apply for stay of winding up order before filing its appeal. It is less likely XYZ will be successful in its appeal, because based on our grounds of discussion, all that, all this is not problems. It was XYZ fault. Actually, NBC did everything right, even though the fact is not silent on the advertisement issue, all that. ABC, I think, is already compliant to most of the winding up procedures that's provided in our law. So XYZ will not be likely to succeed in its application. Okay, so this is my submission. So every question, please put a conclusion or submission. What is your stand? Okay, so Z and N also applies to set aside bankruptcy petition filed by ABC Banks against them. So advise ABC Bank, again, read the question properly, advise ABC Bank, not Z and N, based on the provisions of section 5 sub 3 to 7 of the Principal Act, and decided case whether Z and N can succeed in their application. So my suggested answer, I will just, I say if I blank, I don't know what to write, I'll write reference is made to section 5 sub 3 to 7, in which I will describe N and Z are other guarantors under the meaning of section 5 sub 3 sub B. That means to say they are not social guarantor. Okay, the bank, the what we call the law provides limited protection. It's not no protection at all, limited protection against those category of guarantor. Because eventually you must always think back, who owe the bank money? Is the XYZ Sandra Bahat that owe the money? N and Z, they are just guarantee, just act like a commercial guarantor, for the loan, So it is XYZ that default the payment. So why must this N and Z bear all the legal consequences? Okay, so there are some limited protection by the law open these categories of person. So what is the protection? ABC Bank must obtain leave of court before commencing bankruptcy action against them. So my case is very simple. The Hong Leong Bank against Khairul Nizam. On the fact ABC Bank did not obtain the leave of court, this error must be rectified because you are advising the ABC Bank. So you must tell them this error quickly, you correct it. Okay. So ABC is advised to proceed to foreclosure of the land and exhausted all modes of execution of enforcement to recover debts owed to him by XYZ Bank. So because the question had requested us to answer this based on this provision. So to fall back to section 5 subrule 4. So must exhaust, must sell the land. Okay. The said modes of execution and enforcement include seize and sell, JDS, okay, the judgment debtor summon, garnishment and winding proceedings against XYZ pursuant to section 5 subrule C. So ABC had not yet done anything, had not done the foreclosure proceeding before commencing a bankruptcy proceeding against X and Z. So in submission, it will be advisable for ABC Bank to comply with the requirements. That means to say must sell the land and go for the company XYZ first before coming to the N and Z. Okay. Otherwise, the court shall dismiss the petition by virtue of section 5, subrule 7 of your Insolvency Act. That means the creditor's petition will be dismissed. Okay. So you can use the case here, Hong Leong Bank against Ong Mun Huat. Okay. The laws are more important than case law. Please remember that. Okay. So we still have 3 questions to do. So we have to be slightly quicker. 2020 supplementary question A. So Lim was actually sued by Nabisco Sdn Bhd for debt of 100,000 ringgit outstanding since 2016. So we look at the judgment debt, all that. It's still not time bar yet. Okay. Usually it's not time bar. Lim filed a counterclaim against Nabisco for 150K. So both Nabisco's claim and Lim's counterclaim were dismissed in October 2019. So the whole story, no story. Okay. So what happened subsequently? Nabisco filed another suit against Lim for 1.5 million ringgit, which is a subsequent debt that arose in August 2020. Summary judgment was entered against Lim in December 2020, but only for 1 million. Lim appealed the summary judgment and the appeal is pending before Court of Appeal, while Nabisco cross-appealed the decision of the judge in granting summary judgment for only 1 million. So what happened here is this summary judgment, both the plaintiff, Nabisco, as well as Lim were pretty unhappy. Okay, they both appeal. One appeal said that judgment should not be granted. Nabisco cross appeal said that, wait, why so little? Why 1 million? By right, it should be 1.25 million, correct? So both are not happy. So this is not a final judgment because now we are looking at the question is likely to be bankruptcy issue, individual, okay, individual. And Lim's application for stay of execution was dismissed by High Court. Okay, cannot get a stay, but judgment is still not final. Okay. However, Lim filed another application for stay of execution, has yet to be heard by Court of Appeal. That means High Court, okay, I apply stay, but the High Court just say no. Because I did not get stay of execution, I was not very happy. So I go up another level, Court of Appeal. So pending to be heard. Okay. So what Nabisco did on 14th of January 2021, finds out that there is an outstanding bankruptcy proceeding against Lim initiated by ABC Bank on 1st October 2020. Okay, so apparently Lim did not only owe to Nabisco, Lim also owe to one party. It's called ABC Bank, and ABC Bank had already on 1st of October 2020 pass a bankruptcy notice, to Lim. Okay. And Nabisco proceed to initiate bankruptcy proceedings against Lim on 2nd February 2021. Okay. The purpose is one, if let's say ABC got the bankruptcy order faster than what we call than the Nabisco, probably um, all the assets, all the properties belong to Lim will have to go to ABC Bank first, because presumably, if let's say ABC position is same with Nabisco, both are unsecured creditors. First come, first serve. So this Nabisco cannot wait. So it also initiated a bankruptcy proceedings against Lim on 2nd February and managed to serve bankruptcy notice on Lim 10 days later. Okay. So in meantime, after serving the bankruptcy notice on Lim by Nabisco, so Lim realized that Nabisco had failed to pay him for services rendered to Nabisco, in which he had issues invoices for in August 2020 for the sum of 1.1 million. So Lim suddenly, actually, he realized there is some set-off or counterclaim here, 1.1 million. So more than the 1 million that actually awarded by the court. Okay, so far we can follow on this question. So we are asked to advise Lim on his chance of challenging the bankruptcy notice initiated by Nabisco against him on 2nd February and the procedures that Lim must comply to challenge the bankruptcy notice. So if you get this question in exam, please do. Very simple, very straightforward. Please do. Okay. So short, I mean the facts as compared to the previous years. So you must do. And it is only limited to the issue of bankruptcy notice, not even gone to creditor's petition. So why not? So what we'll do is, okay, this is my suggested answer. Okay, in order to challenge the validity of bankruptcy notice, the following issues shall be addressed by Lim. My preferred style, as you may know, I prefer to do in a headings. What we call something like this. I will draw a line and then I'll put what I want to discuss so that I don't confuse myself and I'll get my points, something like this, So I'll put myself in such a way, heading. So the summary judgment was given by court around December 2020 for 1 million against Lim. Subsequently, Lim had appealed to Court of Appeal for the summary judgment and stay of execution. Okay, make it very simple. Do not write too long because he appealed for both. Okay, and Nabisco had issued the bankruptcy notice hereinafter BN on the February, and the BN was subsequently served to Lim after 10 days. Based on the fact there was no recognizable legal issue pertaining to the service of BN. So I said BN is okay to be served. But at the material time, is BN found on final judgment? Okay, I would say no, because the Nabisco and also Lim both together, they were not happy with the judgment with the High Court. So they already appealed. This sum itself is never a final judgment. So you must put it here. And there was an appeal for stay of execution. Therefore, I will put the Form 34, your what we call the bankruptcy notice itself, pertaining to your Rule 89, and also the main act, Section 3, Rule 1, Rule I. As we have repeated the question, you can always see this, Section 3, Rule 1, Rule I. So please go back and read the slides and get a better understanding about what this provision talks about. Okay, I'll use the case of Recon here, okay, to say that there is not final judgment and there is a stay. So infringe, okay, the Section 3, Rule 1, Rule I. Been unhappy with the sum award in summary judgment. Nabisco also cross appeal on the quantum of the awards. It could be concluded that the total amount of final award may be varied by the court. Thus, the amount in the bankruptcy was inaccurate at the time of its issuance. So you must infer from the fact, correct? Because now it's only 1 million. Everybody is not happy. So not correct lah. So I use the case of Fazia Osman against BBMD. So the error was not curable under Section 131IA or Rule 274, the insolvency rules. Whatever that hit the Section 3, Rule 1, Rule I, the principal act cannot cure. Okay, it's a compulsory provision. Okay, cannot cure. It is submitted that BN was defective and invalid for the said reason. Okay, so you must look at another bankruptcy proceeding by ABC Bank also, because a lot of they put in quite a few sentences about this, right? So the facts reveal that ABC Bank has separately initiated a bankruptcy proceeding against Lim. BN was issued on 1st of October, but it was not served at all. So pursuant to Rule 94 AR, a bankruptcy notice is valid only for 3 months from the date of issuance and shall be served within 3 months from the issue of bankruptcy notice. The facts were silent on whether ABC Bank had applied extension of time or not. Okay, pursuant to case of Yap Heng Chong here, should the bank did not apply for the extension of time for the service of BN with any good merits or special circumstances, the bankruptcy notice issued on 1st of October will be invalid. Okay, because expired already. So you must submit whatever ABC bankruptcy is invalid. Okay, otherwise it will be an issue also. Okay, so procedure to challenge. So Lim should be able to challenge bankruptcy notice on 2 grounds. Number 1 would be the bankruptcy notice is not based on final judgment. Okay, and the exact claim in the bankruptcy notice was not certain. I will put here non-compliance to Section 3, Rule 1, Rule I. Okay, so for this matter, Lim may apply by summons in chambers. Remember, always is summons in chamber, supported by affidavit within 7 days to set aside the bankruptcy notice. Okay, Rule 17. Please remember this rule, Rule 17, insolvency rule. So, because in the text itself, it mentioned that Lim also had some claims to Nabisco, right? So you can say Lim has cross-claim, set up or counter-claims. Okay, the facts inform that Nabisco had failed to pay Lim for services rendered in August 2020 for the sum of 1.1 million. Such amount was actually greater than the 1 million by Nabisco in the judgment. So under this ground, Lim may file an affidavit and within 7 days to set aside the BN. So this is pursuant to your Rule 93 insolvency rule. So in conclusion, what you can do, when we consider the issues of defective bankruptcy notice and limbs potential cross claims, set off, or counterclaims, it appears likely that his opposition against bankruptcy notice will be successful. Okay, so as simple as that, So this question are really worth to do. Okay, really worth to do. Okay, we'll go to question year 2021. Okay, Baron is the shareholder of a company called Diamondback. So Diamondback, what it did, deals primarily in illegal arms funding to avoid bringing any attention to the business of Diamondback. So Baron took a 25 years term loan in January 25 from Central Bank of Barak, the bank club, okay, in the sum of 30 million ringgit. So Baron informed that the term loan was actually for alleged purpose for setting up an investment fund management company. So the term loan was fully drawn down by February 2005. The term loan was secured by third party national land code because the amount is big. So the bank probably will require a charge of the land to be secure creditor. In case anything happen, I still have the land with me. I can sell the land to recover my loss in case of anything happen. So the land is actually third party. That means not belong to Baron, but Baron's wife, Lucinda. A corporate guarantee given by Gan Sanjaran Bahad and a personal guarantee given by Baron's son, Hope. So this one a little bit complicated already. So this loan itself is backed by one land belong to Lucinda, corporate guarantee, Dan Sendirian Berhad, as well as court, Baron's son as other guarantor here. Okay, so who executed the personal guarantee at the time when he was a university student. So quoting lah. So Baron defaulted in the installment payment for the term loan in January 2020. So in March 2020, the bank initiated civil proceedings in KL High Court against Baron Gan Sendirian Berhad Court, as well as foreclosure proceedings against Lucinda. Okay, fair enough. Because Baron is the borrower, you must distinguish. Baron is the co-borrower, Gan, corporate guarantee, Court, other guarantor. Lucinda, third party, legal charge for her land. So summary judgment was obtained on 14 August jointly and or severally against Baron Gun Court in the sum of 8.5 million with again interest thereon from the date of judgment to the date of realization based on the rate of 0.5% over the current base lending rate of the bank, which was 6.45 per annum at the date of judgment. So by the time of reading this, you already start forgetting what happened in the first place, correct? So very complicated question. So Baron Gun and court appeal the summary judgment decision to Court of Appeal. So apparently not final judgment yet. So on 29 September, the High Court granted Baron Gun and Court a conditional stay of execution pending their appeal on the condition that pay jointly or severally into a court a sum of 4 million ringgit within a month from the granting of the order for stay, failing which the same shall lapse. That means to say the court actually granted the stay, but it is just on one condition. All the parties must pay to the court 4 million. So in the meanwhile, despite the bank being aware of the conditional stay order, the bank aware, So on 29 September, had nonetheless on 2nd October initiated bankruptcy proceeding by taking out and serving on Baron Court separately bankruptcy notice. So this one is against individual. Okay, against individual. So the bank was successful in personal serving on Baron Court their respective bankruptcy notice. So service is okay, it's by personal service. So the bank at the same time issue a notice pursuant to section 466 subrule 1 subrule A, inability to pay the debt against Gan Sendirian Berhad. But preferably, you should use section 465, subrule 1, subrule E. I don't know why they use this. Based on the summary judgment obtained on 14 August. So Baron Gun Court failed to pay 4 million into the court on the stipulated deadline, resulting in the conditional stay lapsing and being no effect. So quite complicated. One is against company and another is against Baron. Baron borrower, court, other guarantor. So first we were asked to advise Baron and court on the procedure to be adopted for challenging the bankruptcy notice and their chance of success. So here we forget about Gan Sedera Berhad, we forget also about the Lucinda punya charge. So not relevant. Okay, so what we'll do next? We must identify that Baron is the borrower and court is other guarantor. Okay, university student, I suppose he is not a minor. Okay, but is there an issue of leave of court here? We'll discuss that. Okay, we'll discuss. So my suggested answer, in order to challenge the validity of bankruptcy order, my standard, I will put in such a way. Otherwise, I'll put reference is made to Insolvency Act 1967. I'll put IA and also Insolvency Rules, IR, to make myself easier later part. Okay, so I'll put a few heading: unlawful or illegal firearms trading. On the fact, it was told that Baron was involved in illegal arms funding. There was issue of separate corporate personality, and Diamondback was not the actual borrower in the loan transaction. The loan between Baron and bank could not be null and void because, as we all know, any contract that involved in unlawful activities or it was held illegal by law will be null and void. This is the basis of our Contract Act, apply across to all the contracts in Malaysia. But then I say it is not void because Baron is the one that borrowed from the bank. As we all know, bank commenced action against Baron, Gun, as well as court. Okay, so Baron is the borrower. I will say that the summary entered by the bank against Baron and court was valid. Okay, so I'll put my further argument: court is actually other guarantor because it's not social guarantor. Court was deemed to be other guarantor and he could not fall under the meaning of social guarantor as provided in section 2 Insolvency Act of your 1967. That is the interpretation clause for social guarantor here. So he's not social guarantor, as he had acting as a personal guarantor to secure the loan for his father business/commercial purpose. The other guarantor was actually provided in, you must remember, a lot of questions already asked you about this issue. Section 5, subrule 3B, okay, Insolvency Act, in which the bank must obtain leave of court before commencing any bankruptcy proceeding against court. So Section 5, subrule 4 further provides that the bank must exhaust all modes of execution and enforcement to recover the debts owed to him by Baron. Did they do so? Apparently, it was not obeyed, as the bank had commenced actions against court at the very beginning without taking proper execution on the company and Baron, because company is also there. Why court alone has to bear all this consequence? So you must exhaust the execution against Baron, including making him bankrupt first before you come to me as a other guarantor. So this is what I'm trying to submit here based on Hong Leong Bank against Ong Mun Hua. And what are the issues regarding those summary judgment? The summary judgment was actually given by court on 14 August. Baron Gun Sendirian Berhad and court, the appellants appealed towards the state judgment, and the court had granted conditional stay of execution of 29 of February, with 1 month period for the appellants to pay into the court of a sum of 4 million. So conditional stay is there. But the bank had willfully ignored the stay order and had issued bankruptcy notice on 2nd of 10, So that means actually by right, this conditional stay will still valid until you plus another month, 1 month will be 29 of October, because you issue too fast. At the material time I will submit, BN was not found on a final judgment and there was a stay of execution. So I will put myself the form 34, rule 89, insolvency rule, as well as of your primary act, section 3, subrule 1, subrule I, insolvency act were infringed against Ri Lo Kun Wah. The summary judgment was awarded jointly and or severally against Baron, Court, and Gunn. The facts did not reveal that the court had actually apportioned the exact sum owned by each party in certain and unambiguous manner. Again, there's an issue of 8.5 million, but how much to pay? By who? Is it by division of the by 3? Or Baron pay 50%, court and also Guns and Darren Bahad pay another 25%. We do not know. So in this matter, even if the bankruptcy notice was served separately to Baron Court according to Rule 89, however, it is disputable that the exact sum was stated clearly in BN. Okay, that means to say the bankruptcy notice is not certain. Okay, because the judgment give you 8.5 jointly or severally. We do not know what is the quantum for each party. Okay, so furthermore, the interest in the summary judgment was not quantified properly by the bank. Open issuance of bankruptcy notice. Okay, so I will use the case of against Fauzia Osman against BBNB. It was held that the amount in the BN must be quantified accurately because it goes to the root of section 3, subrule 1, subrule I. And it is not curable, remember what I said. And it is submitted that BN was defective and invalid for the said reasons. Failure of Baron and Court to obey the conditional stay order did not have any legal bearing on the invalidity of BN. Okay, even though Baron and Court Guns Berhad had failed to materialize whatever promised by the court, but the stay is still ongoing during the issuance of bankruptcy notice. So it's not important. Eventually, you can issue later. Why in such a hurry? Okay. So this is how. And the procedure that I propose would be Baron and Court are advised to commence action separately to set aside their BN because one bankruptcy, you cannot combine so many people. It's not like a consolidated proceeding. You must file separately. So within 7 days, file summon in chambers supported by affidavit to say that BN had been defective for the reasons as discussed above against Rule 17. Maybe you can use the case of MBB against Dato' Lim Ken Kim. Okay. The defect pertaining to the exact sum not quantified in BN was fatal and not curable under Section 131 or Rule 274 as discussed supra. Okay, conclusively, Baron's and Court's chance of success are high enough to set aside BN. Put a conclusion, okay, after whatever you have discussed. Just bear with me for maybe another 5 to 10 minutes. Okay. This question, 2022 one, frankly speaking to you. Okay. I did not do it during my examination because I feel that it's very risky, because I feel the question itself is not like the previous one. It is an open question that invites a lot of discussion, you know. So I try my best to answer accordingly, but if you make this sort of ambiguous question in your examination, it is my advice for you to switch to another question that you feel more confident to do. Do not waste your time on this sort of uncertain question. I'll explain to you why. Okay, Abu is working as a GM in Lux Bank with an income of 45,000 per month. Not bad. And also entitled to yearly bonus of 120,000. Okay, Abu had been working for 15 years, so loyal employee. And due to his excellent performance as the GM, he was given a house value at 150,000 ringgit. So not bad, the benefits of his bank. So Abu also owns 2 apartments. He obtained a housing loan for 450,000 from Bamboo Bank in 2018 to purchase both apartments in Sinaran Mega at KL, which are worth 550,000 in total. So borrow 450,000, but actually the house worth about 550,000. So in 2020, before COVID, Abu took a second loan from Bamboo Bank and purchased another apartment, Bukit Aman apartment, which is worth 250,000. So here, the fact is silent. How much actually he owe the bank? He take loan how much for the Bukit Aman apartment? You know, we do not know. Okay. So Abu rents both apartments in Sinaran Mega with a total monthly income of 6,500 ringgit. The 2 apartments at Sinaran Mega are charged to Bamboo Bank, and apartment located at Bukit Aman apartment, which he resides at, is also charged to Bamboo Bank. So everything got charged now. The Bamboo Bank is a secure creditor, first party legal charge. Okay, secure creditor. So Abu has a very extravagant lifestyle, and he likes expensive cars and holiday. Despite he's earning well, but he spent a lot also. So due to this, Abu started defaulting on his housing loans repayment with Bamboo Bank. Abu moves out from Bukit Aman apartment in June 2020 and now stays with his girlfriend in Taman Maruri, Selangor. So move to girlfriend, tumpang rumah. Okay. Abu sent a letter to Bamboo Bank on 25th June 2020, informing the bank that he will continue to pay his housing loan in statement payment. But due to COVID pandemic, he requested for time to pay the coming installment payments. So Bamboo Bank agreed to give him 6 months extension from July 2020 to the end of December 2020. Okay, we have yet to see any issues here. Extension of time was given by the bank for COVID reason. Okay, so in January 2021, Abu defaulted. So separate issue. Abu defaulted on his loan, and he has since resigned from his job at Lux Bank. Now he's jobless, and somehow he defaulted the loan. Bamboo Bank has sought assistance from his girlfriend to find him, but he's unable to provide Bamboo Bank any information. So in March 2021, Bamboo Bank received another letter from Abu enclosing a check for outstanding loan payments for January 2021 until March 2021. So Abu managed only to cough out the money, okay, for January until March, okay, 2021. But he requests more time to repay the loans from April 2021 until December 2021. So this time, okay, the bank did not allow. The Bamboo Bank rejects the request from Abu. Since then, the bank is unable to communicate or locate Abu again. Bamboo Bank now seeks your advice as to their next course of action against Abu. Right. So the first question asks us, advise Bamboo Bank on the possible acts of bankruptcy committed by Abu. under the Insolvency Act 1967. So I invite you all to have a look at your section 3, Acts of Bankruptcy. And my suggested answer shall be based on section 3. Okay? Okay, I'll put myself in such a way because I want to be safe to answer this sort of open-ended question. In usual scenario, as I have told you, before commencing bankruptcy proceeding against an individual, you must have a judgment. Now, you know or not whether Bamboo Bank had got any judgment. I think the facts is silent on this issue. So, but still, to be safe, to show that the examiner that I know about this, I'll put my intro in such a way. The facts were silent on whether Bamboo Bank had obtained any judgment from the court prior to commencing the bankruptcy proceeding. Therefore, Section 3, Subrule 1, Subrule I, the popular one, could not be said to be committed by Abu. Okay? I'll say so because I do not have a solid fact to support that. No judgment. Okay? Court did not give any judgment. But subsequently, I will say it is possible that Abu had committed the act of bankruptcy by, okay, it's looking at this one is a little bit unusual, which make me hesitate to answer for what we call this year punya question lah. Okay, so section 3, subrule 1, subrule D, subrule 2. Okay, it says that departs from his dwelling house or otherwise absents himself or begins to keep house or close his place of business. Okay, so I will relate this with the facts. Okay, apparently Abu had departed from his apartment in Bukit Aman and absent himself from being contactable or reachable by Bamboo Bank since his last correspondence in March 2021. After his extension of time, he gave a check, isn't it? January until March, he can pay. After that, April to December cannot pay. Okay, so I feel that there is something here. So with the intent to defeat or delay the creditor, Bamboo Bank. So he committed section 3, subrule 2. And apart from that, I held that section 3, subrule 1, subrule G. Okay, if he gives notice to any of his creditors that he has suspended or that he is about to suspend payment of his debts. Okay, look at this provision. I will help myself with, I do not copy from the provision, and it is very time consuming for you to copy from the provision. So straight away answer based on your understanding. So I'll put it this way. By his letter in March 2021, tantamount as a notice to Bamboo Bank that he has suspended or about to suspend the payment of his debts from April to December 2021. The fact says so, correct? So I said that in submission, Abu had committed the act of bankruptcy by virtue of section 3, subrule 1, subrule D, subrule Roman 2, and section 3, subrule 1, subrule G of your Insolvency Act. The act of bankruptcy is precondition for commencing a bankruptcy petition. So, Refadzir Osman against Malayan Building Limited. Okay, so this is my answer for 2022 question. Okay, so we go on with a more confusing question, which I myself, I'm not sure whether I interpret the question rightly, Okay, so, but anyhow, I seek advices from senior as well as my master. I think this is the most likely answer, okay, for this question. So B, Bamboo Bank is aware that it will be advantageous for the bank to obtain a judgment against Abu before initiating bankruptcy proceedings against him. Assuming Bamboo Bank obtained judgment against Abu, Bamboo Bank now seeks your legal advice on the following. 1. whether it is able to file a bankruptcy petition without first realizing the security. That means the bank now he has actually two apartments and in Sinaran Megah, okay, worth about 550,000 is on first party legal charge, as well as one apartment in Bukit Aman, okay, value about 250,000 also on the chart. So the question asks, without actually going for foreclosure or order for sale, can go for bankruptcy petition first or not? Okay, my answer is this way. So Bamboo Bank is the secure creditor by virtue of Section 2 Insolvency Act 1967, where it holds two apartments in Sinaran Megah and one apartment in Bukit Aman on first party legal charge. So Section 5 Subrule 2 Insolvency Act provides that if Bamboo Bank proceeds to bankruptcy petition without realizing the security, it must state its willingness to give up its security for the benefits of other creditors. That means to say, whenever you want to proceed, you are the secure creditor. By right, you have vested interest in the land. The best option for you is actually to sell the land and get back whatever money that Abu had owed you. But this way, if you are choosing to, who use? eh, Can you all still hear me? Suddenly I log out.
Yeah, can.
Can okay. Sorry. Suddenly I got logged out. Okay. So okay, we continue. Section 5 Subrule 2 Insolvency Act provides that if Bamboo Bank proceed to bankruptcy petition without first realizing the security, it must give up the security for the benefits of other creditors. Okay. And second thing, it must give the estimated value of its security and an extent of balance owed to it. So that means to say the Bamboo Bank must engage with valuer, okay, to assess the property value and deduct with the balance. Okay, then the Bamboo Bank shall be admitted as unsecured creditor thereafter. So actually not a good position for the bank, pursuant to your case of M. Muhammad Hashimi Ibrahim against Asia Commercial Finance. So in case of, this is what I have done my research, Cheng Ying against Exim Bank, it is held that bankruptcy petition will not be stay pending for the realization of securities unless sufficient reason could be shown under Section 97 of your Insolvency Act. The sufficient reason here means Abu could pay the debts or securities. Okay, that means the facts were not adequate to establish whether sufficient reasons on part of Abu. So I submitted that actually Bamboo Bank could proceed with bankruptcy proceeding before realizing the securities. Okay, this is my understanding in regards to this question. And question number 2, whether it is able to file a bankruptcy petition after it has realized the security by way of foreclosure. Okay, that means to say the bank already sold, auction the 3 properties that he hold. Okay, so can he still file a bankruptcy proceeding against Abu? Okay, I will submit as such. Okay, as a secure creditor, the Bamboo Bank can actually proceed to foreclosure over the properties charged to it pursuant to Section 5 Subrule 2 Insolvency Act. The assets owned to be taken into consideration are inter alia 2 apartments, one apartment in Bukit Aman. And the fact was silent on the total loan owed by Abu. It was only revealed that Abu owed bank for 450,000 for charging his 2 apartments in Sinaran, Megah. I will put myself in a safe position. It will be depending on the balance of debts after the foreclosure. See how much the house sold in the auctions, then we deduct of the amount owed. Okay, if the amount derived from the foreclosure itself is not sufficient to meet the loan, it is advisable for the bamboo bank to lodge a proof of debt. Okay, that means you must list down whatever is your loan. Okay, if it is more than the amount prescribed, that means more than 100,000, pursuant to your section 5 subrule 1 subrule A, bamboo bank can commence bankruptcy proceeding after the foreclosure. So this is my understanding on this question. The case of Su Kok Long against HSBC. Okay. The third question even worse. What should the bank do if Abu has already been made a bankrupt? So I put my answer in 2 versions because this is a super open question. It's like no definite answer. What should the bank do if Abu has been made bankrupt? The issue is when did Abu make bankrupt? So is the issue pertaining to whether the bank wanted to make Abu to have a second bankruptcy or not? So this is my argument. The question this year, frankly, I have prepared, but I cannot do, because it's too risky. You may lose a lot of marks and then you will end up failing. So better don't challenge them. Whatever question that you cannot understand, something wrong, don't do. Okay. So my submission is as such. Bamboo Bank, again, I repeat myself, a secure creditor may deal with a bankrupt property under Section 8, Subrule 2 of the Insolvency Act. This is based on your case of Perwira Habib Bank against Samuel Pakianandan. The bank has right for interest if the property is realized within 12 months from the date of the first bankruptcy order, pursuant to your Section 8, Subrule 2, 2A, Insolvency Act. This is undetermined as the facts were silent on when the bankruptcy order will issue on Abu. The bank may seek legal action to realize the property of a bankrupt, i.e. to proceed with order for sale under Order 83, Rules of Court, as well as your National Land Code. Depends on whether it's a registry title or it's a land office title. So the surplus after the sale will be given to DGI to be credited back into the estate account of the bankrupt to be distributed to the creditors. So this is my submission. But I also have another alternative answer. So if Abu has already made a bankrupt pursuant to Section 49, second bankruptcy is allowed. So I don't know what the bank want. Because the facts is inadequate, whether it want to commence second bankruptcy on Abu or not, but it is found in your syllabus. So I have a dilemma in answering this question. So, but to be safe, I put both for your reference. You just choose whatever you feel that is right for you. Okay, however, the two, okay, so I will put in such a way, if Abu has already been made a bankrupt pursuant to Section 49, second bankruptcy is allowed. However, the two must be administered separately. The bank should be aware that the property acquired by the bankrupt after single order bankruptcy order must be treated as asset belonging to first bankruptcy. That means the first bankruptcy order is there. Whatever assets by right should go into the first bankruptcy order in your creditor list, because they already given to them. The asset cannot benefit the creditors in the second bankruptcy until the creditors in the first creditors have been paid in full. Okay, case of Osman bin Abu Bakar here. So that means the bank is in a very bad position already. Okay, Sama Credit and Leasing Sdn Bhd against Pegawai Pemegang after Malaysia. It was worth noting that the Bamboo Bank could not apply to annul the first bankruptcy order, as power to rescind and annul a bankruptcy order is discretionary, and appellate court would not disturb the finding of High Court unless there's a strong case to do so. So this is also in advising on what to do for the Bamboo Bank. So I seriously have no idea what they want. So at the best interest of Bamboo Bank, instead of proceeding into second bankruptcy order, it is better for Bamboo Bank to realize the securities. So I will still put my submission in such a way that first party legal charge proceed to foreclosure within 12 months of the bankruptcy order so that the bank can still get some interest back. So Section 8(2)(a) Insolvency Act. Okay, RHB against Yaakob Muhammad Khalid. Okay. Oh, finally we have done the. I think I need to stop recording.